And I'm actually going to start with a follow-up question that was proposed by someone in the audience here. There's an interesting question by way of follow-up to Brian's story about the retainer that George Walker received and took to the bank, and ended up with the police at his door announcing that the retainer turned out to be counterfeit money, and asking George where it came from. So the question is essentially this: what did George do, and what should George have done?
Well, George obviously was on the phone asking me what I thought he should do. I felt somewhat comforted by the fact that, you may know, George was articled to G. Arthur Martin just prior to Justice Martin's elevation to the Court of Appeal, and he had tried to reach G. Arthur, and I don't remember whether he had reached him or not, but he asked what I thought. My view was, and this was long before the era where at that time conventional wisdom was that, by the way, that a lawyer's trust account at the time was not a matter of privilege. And that was a function of a series of cases that arose out of the Graham Trust matter. Subsequently, as you may know, the Supreme Court of Canada has held that the identity of a client's trust, or the client's identity in relation to trust funds held by his or her solicitor, is a matter of privilege, and you don't have to reveal the identity of the client. But I thought this was something different. My view was that the client had engaged the lawyer in the commission of a crime, that the police were going to come at the door, and it wasn't simply a matter that they might threaten George with arresting him for having been involved in depositing counterfeit money to his account, but it was a matter of the fact that the client had in fact utilized George to attempt to launder counterfeit money, and had used the solicitor-client relationship in an improper way. And my view was you could reveal the identity of the client, and I believe George did, and he agreed with me and followed it.
Eddie?
Well, just because that you feel hard done by the client, that you feel used by the client, that you're upset because the client has used you, well, take your upset and go home, have a beer, and watch television. You have a solicitor-client relationship, and unless there is some specific kind of rule like the Graham Act matter, which may have forced it, but today, you want to find out anything about the trust account, and how you subpoena me, you get a judge to rule that I have to answer it, and then I'll answer it. But until then, I think the solicitor-client privilege is sacrosanct. I mean, there is one very vitally important thing in terms of the area of privilege, and it's solicitor-client privilege. I have no problem with that. If my client tells me where the bodies are buried in the famous case in northern New York State, well, I'm not going to go and tell the other side where the bodies are. And in fact, just because the government knows these guys killed 3-4 other people, just because he's told me doesn't mean I go tell. To me, it's privileged. I'm not going to do it unless compelled to do it.
Okay. Now I have a follow-up question to that follow-up question, and I'll start with you, Ed. Is that a decision you're going to make on your own, or are you going to call, G. Arthur Martin's not around anymore, are you going to call Brian? You're going to call...
Well, I'm not going to call Brian. I don't like his answer one bit.
Well, are you going to make the decision on your own, or are you going to get some advice?
Let's move away from this one case. And let's say you've got yourself a serious ethical problem, like really, many of them are. Arthur Martin, I remember when he taught this at law school, that most ethical problems are not ethical problems, they're tactical problems. And don't define it as an ethical problem unless and until it is an ethical problem. But on the assumption that you've got yourself a genuine ethical problem, what I will do is I will approach 2 or 3 very senior members of the bar, including my brother, because if I'm going to get charged I want the prisoner's dock filled with every lawyer in Toronto who's agreed with my decision. And I'd rather go to my fellow criminal lawyers than once I actually went to the Law Society, to the Ethics Committee, and I could not believe the answer I got, and I was stuck with it. If I was going to disagree with them and the police found out about it, I'd be in big trouble. But I try to engage as many people as I can in that kind of a decision-making process. You don't want to stand out there alone.
And the added benefit to seeking advice and having a group of people who you've at least discussed the matter with is it's not a secret. Because part of the criticism about ethical decisions made by counsel is that they've kept it to themselves, and there's some notion that if you kept it to yourself, you're trying to hide the decision-making process, and that becomes suspicious. So if you've sought advice, the problem does come up if you seek 3 opinions and they're all unanimous and you decide to go the other way. There's a problem there.
Oh, I think you're in major trouble. If the 3 go against you or the 2 go against you, I think you are, well, whatever you are. I think you have to go with the opinion that you're given, whether you like it or not. I mean, if you want to strike out on your own, it may come back to bite you one day.
All right, let me ask you a question about trials, and particularly mode of trial. Do either of you have a general preference for trial by judge as opposed to trial by judge and jury, or do you have a preference in specific types of cases to go with a jury or go judge alone?
You go first. Okay.
I think the latter. In specific types of cases, I have a preference, generally speaking. And I think that the best example, because conventional wisdom in Canada is the antithesis of conventional wisdom in the United States. As you probably know, most fraud cases, most commercial crime cases, are tried with juries in the United States, almost inevitably tried judge alone in Canada. I say that with some hesitation because I just finished a jury trial on a commercial fraud, but which led to convictions, and that may have indicated my desperation in seeking out a jury in a commercial fraud case. So that there are, part of it, and it's not that I don't have a respect for the jury system and their ability to understand. I don't think that complexity really is the reason that you go with a jury or without a jury, or go without a jury as a result of complexity. But I do think that there may be features to, for instance, a fraud case where you have someone charged with millions of dollars passing through their accounts and leading a lavish and grand lifestyle, that there is a potential for resentment, there is a potential for the image of that greed is something that perhaps judges somehow, I don't think that they accept, but nevertheless would better apply the legal standards to the issue as opposed to bring any prejudice against the accused on that type of case. At the same time, I think most of us try a lot of sexual assault cases without a jury, and I think that that's almost has to be determined on a case-by-case basis. I don't think there is a general rule. And despite the fact that virtually every murder, because murders require consent of both parties to proceed judge alone, most murders are tried with a jury. I think that there are some cases where there are purely legal issues involved, as opposed to factual issues on homicides that might better be tried without a jury. So I think it's a case-by-case analysis. I don't think I have a strong preference other than commercial crime. And quite frankly, although the vast majority of the work I've done in the last couple of decades has been without juries, from a pure enjoyment point of view, from a pure have fun in a cross-examination, I much more enjoy having the audience as a jury rather than the judge. They actually laugh at some of my my questions and have fun, and it's a lot, the interaction with the jury is a lot more sort of personal in some ways. And I think that just from a pure enjoyment as a professional, I think it's more fun having a jury, but I think that you have to decide each case based on its facts and based upon the profile of your client as well.
Well, for me, it's not a question of fun. For me, it's I mean, every one of us is very different. We're made up of a whole bunch of molecules, and we're made up of a whole bunch of things that go together in terms of you personally being of the kind of personality or the kind of character that you're more comfortable in front of a judge alone or more comfortable in front of a jury. I love juries. Okay? Unabashedly love juries. The cases I love the most are first degree and second degree murder. I have no choice. Okay? I'm going to have a jury. I don't even have to talk about it. And I hate having to not go with the jury. But, like any other lawyer, if I'm going to go with a jury and I walk into court and they give me Judge Y on the day of trial, I've got to be a fool not to re-elect and go in front of Judge Y. And I think sometimes they actually do that to me. They put in a judge who you just can't do better than that judge alone. The cost is cheaper for the client. The result is probably going to be as good, if not better, with the judge alone. Then you have to do it. But if you're comfortable with juries and you like juries, I think that will color your view as to whether there should or there shouldn't be a jury trial. And we had a jury trial in the dredging trial. It went 14 months. And everybody in town was on the case, and Judge Parker was the judge. Complicated case. Jury addresses took weeks. And the jury went out for weeks, and they came back, and they actually did what we all believed was the right thing. At the end of the day, one guy, they convicted on 4 counts, and they hung on the count they should have hung on. I believe jurors are not that stupid at all. And I think it's much more interesting to work with a group of 12 people. I mean, juries are obviously, much different cats than a judge. I mean, Brian's just shown that, some juries actually laugh at his jokes. I mean, that means you can probably sell a jury, a lot easier than you can a judge alone. But I just think that it's up to you. That we all make excuses about why we don't want a jury trial. And when the fact of the matter is we're really happier with the judge alone. And I think that's where you have to start. Where are you best suited? Where are you as a lawyer going to make the best impact on the case and get the best result for your client?
Just a brief aside about Eddie mentioned the dredging case, and every time he mentions it, I have to tell you that David's father, the great Dave Humphrey Sr., was on the dredging case. And at that time, at 361 University, it was at 11:30, everyone was there. It was a hotbed of activity. It was mentorship built in to the way in which the collegial criminal bar operated. And there were great debates and great fun. And every day during the dredging case, and this dates the dredging case, because this was the big money case of all time, Dave Humphrey Sr. would walk in and say, "Another grand day." And then he would also say, "Before this case, I thought gravy train was a dog food."